5 seconds to go. Start. The learned senior counsel submitted that sub-rule 3 of the Rule 74 makes it abundantly clear that in case of any contradiction between the certificates mentioned in sub-clause 1 and 2 of the sub-rule 3, the authority deciding age may refer the matter to a duly constituted medical board, which in turn shall record its findings and submit it to the Juvenile Justice Board. The learned senior counsel submits that there is an apparent contradiction in the documentary evidence on record in the form of various certificates, and in such circumstances the matter had to be referred to a duly constituted medical board, and the age has now to be determined on the basis of the report of the medical board which is on record. The learned senior counsel submitted that the certificate issued by the medical board makes it abundantly clear that the age of the respondent herein at the time of commission of the offence could be between 19 and 23 years. In the last, the learned senior counsel submitted that the case on hand is one of a very heinous crime committed on a minor girl aged 8 years. He would submit that if the plea of juvenility or the fact that the accused had not attained the age of discretion so as to understand the consequences of his heinous act is not free from ambiguity or doubt, such plea cannot be allowed to be raised merely on doubtful certificates evidencing age, and in such circumstances the medical evidence will have to be given due weightage while determining the age of the accused. In the aforesaid context, the learned senior counsel placed strong reliance on the decision of this court in Ramdev Chauhan alias Rajnath versus State of Assam 2001-5 SCC 714. In such circumstances referred to above, Mr. Patwalia, the learned senior counsel, prayed that there being merit in his appeal, the same be allowed and the impugned order passed by the High Court be set aside, and it be held that the respondent was not a juvenile on the date of the commission of the offence. On the other hand, the learned counsel appearing for the respondent vehemently opposed the present appeal, submitting that no error, not to speak of any error of law, could be said to have been committed by the courts below in determining the age of the respondent. According to him, Sub-Rule 3 of Rule 74 has no application in the present case, as there is no contradiction in the certificates evidencing the age of the respondent accused. He would submit that the respondent accused was born on 23rd October 2002 is crystal clear, and the same is evident from the admission form of the respondent duly filled while seeking admission in the Modern Public Higher Secondary School Hiranagar in the year 2008. He submitted that howsoever the heinous crime may be, but on the date of commission of the alleged offence, if the accused is a juvenile, then he has to be tried as a juvenile in accordance with law and not like any other accused. He would submit that heinousness or brutality of the crime has nothing to do with the object of the Juvenile Justice Act. He further argued that no reliance could be placed on the opinion of the medical board because ultimately it is an expert opinion and cannot be said to be conclusive as regards the age. The learned counsel vehemently submitted that the court may take notice of the relevant fact that there is no certificate document in the case on hand which indicates that the respondent was not a minor or a major as on the date of the alleged offence. He argued that in the event the school record admission form indicating the date of birth is not to be treated as falling in the category mentioned in Sub-Rule 3.2 of Rule 74, then, in view of the Order Number 22 JC certificate issued by the Municipal Committee being available, recourse to Rule 74.3.2 is not at all warranted. The learned counsel, in support of his aforesaid submissions, placed reliance on the following decisions of this court. In such circumstances referred to above, the learned counsel appearing for the respondent accused prayed that there being no merit in the present appeal, the same may be dismissed. Having heard the learned counsel appearing for the parties, and having gone through the materials on record, the only question that falls for our consideration is whether the High Court committed any error in passing the impugned order. Sub Rule 3 of Rule 74, referred to by us in para 28 above, makes it abundantly clear that in the absence of the certificates mentioned in sub clause 1, 2, 3, or in the event of any contradiction arising therefrom, the authority deciding the issue of age may refer the matter to a duly constituted medical board, which in turn would record its findings and submit to the Juvenile Justice Board. The materials on record as looked into by us above reveal no manner of doubt that there are discrepancies in the certificates on record disclosing the date of birth of the respondent. We fail to understand as to why the courts below were not able to take cognizance of such discrepancies or contradictions. Stop.